The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello and welcome to another edition of the Short Circuit Podcast. I'm IJ Senior Attorney Paul Sherman, filling in for your regular host John Ross. With us as always, however, is Assistant Director of the Center for Judicial Engagement, Evan Bernick. And today our special guest is IJ Senior Attorney Robert McNamara. And today we are tantalizingly close to an all Richard Posner edition of the Short Circuit Podcast. But before we get to our three Richard Posner opinions, we're going to start off with a case out of the 11th Circuit. Evan, can you tell us about Jane Doe versus Valencia College?
So this case involves a variety of constitutional claims brought by three former students at Valencia College. Valencia College is a public college in Florida, and these students participated in a highly competitive sonography program. For those that don't know, sonography is the use of ultrasound technology to capture images from inside people's bodies. As part of this program, these three students were compelled, this was nominally voluntary, but in fact they were required to perform transvaginal ultrasounds on one another. Two of the students objected vocally. Actually, all three objected vocally, but were told that if they didn't participate in it, they would suffer adverse consequences. They would be discouraged from working at local hospitals. They would receive bad grades, etc. Two of the students ended up going through with the ultrasounds anyway. One refused to go through and was subsequently yelled at and threatened with bad grades. All of them withdrew from the program. They're now bringing constitutional claims, specifically First Amendment claims on the basis of being retaliated against for constitutionally protected speech. And two of the students are bringing Fourth Amendment claims, claiming that the ultrasounds themselves were unconstitutional searches.
So in this case, the Constitution applies because this is a public university, a public institution.
That's correct. These are government's employees, and they are telling these people to do things. And as a consequence, the constitutional concerns are triggered.
So why don't you start with the First Amendment claims? What did the court below decide, and how did the 11th Circuit approach them?
The district courts viewed the First Amendment claims through the lens of a doctrine that allows the governments in an educational environment to broadly censor speech that it itself controls. It said that the student's speech was school-sponsored speech, and therefore the government could essentially regulate it as it chose. The problem with this, of course, and this is what the 11th Circuit pointed out, is that these students were actually criticizing what the government officials were telling them to do. So this was by no means school-sponsored speech. And as a consequence, it actually comes under the rubric of a fairly demanding test the court has applied to student expression that doesn't materially disrupt or interfere with the school environments in Tinker v. Des Moines. So this was constitutionally protected speech. The government can't censor it well because it's not school-sponsored speech. And therefore, the 11th Circuit came to the conclusion that the district court had gotten it wrong, specifically by dismissing the students' First Amendment claims.
Okay, and so what about the Fourth Amendment claims? What was the allegation there?
Well, the allegation is that these students were forced to participate in something, essentially perform searches on one another by government officials. The district court said, look, the bodily intrusion that's required by the ultrasounds isn't designed for administrative purposes to gather information. It's not designed for the purposes of a criminal investigation. So the Fourth Amendment doesn't apply. And the 11th Circuit said that's nonsense. This is a bodily intrusion upon somebody. The fact that it might have had a purpose that's different than that which we're used to in the ordinary Fourth Amendment context, involving administrative inspections or criminal prosecutions, doesn't make it any different. This was an intrusion. The Fourth Amendment is triggered.
So it's an interesting wrinkle in kind of the case law. You can see where looking just at the doctrine, you could be led astray into thinking the Fourth Amendment really is just a doctrine about the scope of the government's investigative power. Like Fourth Amendment cases are usually about the exclusionary rule. They usually involve criminal defendants. They're challenging investigations, and it's just interesting to see the division between most of the doctrine and what the Fourth Amendment itself actually says. The Fourth Amendment doesn't say you have a right to be free from intrusive government investigations. It says you have a right to be secure in your papers and effects. It's sort of the difference between the right is the right to be free from searches. The right is not to be free from finding. And the government's argument in this case was essentially, well, sure, we were poking around, but we weren't planning to find anything.
Right, so it's an unusual context, and they are an unusual set of claims, but the claims are, I believe, meritorious, and I think that the appellate court did the right thing by taking them seriously, as opposed to the district court, which simply dismissed them.
So the case goes back to the trial court, and the plaintiffs will now have the opportunity to try and prove their case. Well, let's move on now from this to the first of our three Richard Posner opinions, this one involving current vice presidential candidate Mike Pence, governor of Indiana. And this is Exodus Refugee Immigration v. Pence. Evan, take us away.
So this case involves the application of the Federal Refugee Act of 1980. The Refugee Act allows the federal government to grant states funds in order to resettle people from war-torn or otherwise volatile regions within their borders. As a condition of receiving those funds, a condition of the states receiving those funds, they need to guarantee that, among other things, they do not discriminate on the basis of nationality. Governor Pence of Indiana would like to, well, there's no other way to say it, discriminate on the basis of nationality.
And specifically what nationality?
Specifically, he is concerned about Syrian refugees because of, for reasons we'll get into later, he believes that they are a threat to Indiana citizens. He believes that they're potential terrorists. And as a consequence, he is denying private entities with whom the state is contracting to settle refugees the ability to get reimbursements if they settle specifically Syrian refugees.
So the plaintiffs in this case then are not the refugees themselves. Who is the plaintiff in this case?
The plaintiff is a private entity that wants to settle refugees. That it's called the Exodus Refugee Incorporation. It's contracted with the state, and it receives money from the state, but Pence has indicated that if it settles Syrian refugees, it will not continue to receive money from the state. This is with an eye to, allegedly, protecting the populace against the threat from these allegedly dangerous people, a threat that he, as Judge Posner explains in great detail, has nothing to substantiate.
And that's kind of the interesting thing in this case is I think what you see from the lawyers for the government is a move you see from government attorneys in a lot of cases like this, where the government's argument is basically, we're not discriminating against Syrian refugees. We don't have any animus towards Syrian refugees. We believe Syrian refugees are dangerous, and so we would like to exclude them from our state. And you see that in a lot of cases like this. It's a common argument deployed in cases under the Equal Protection Clause, where the government says, look, we're not discriminating for the sake of discriminating. We're just trying to draw this distinction based on this reason. And I think it's telling that skips an important step because, as Evan said at the beginning, you are discriminating against Syrian refugees. The question is whether you have a good reason for doing so. And so the government's argument is basically, we can't be discriminating because we have a good reason. But it's a two-step inquiry. You are, in fact, making that distinction, and the court's job is to figure out whether you can bring any evidence to bear that says this distinction makes sense in this context.
Yeah, I think this is something that we see certainly in a lot of our cases where, and people who are not as familiar with constitutional law don't necessarily understand how courts do this sort of analysis. But the first question in basically any case is, what's the standard of review? How closely is the court going to look at this? And then under whatever the standard of review is, does the government have a good enough reason for doing what it wants to do? And what the government tries to do all the time is lower the standard of review by saying they have a good reason. And it's an attempt to kind of get out of meaningful judicial review, but it doesn't seem to have worked in this case.
No, it didn't. Judge Posner makes the point that the statute itself doesn't say you can discriminate if you have a particularly good reason to discriminate. It says you can't discriminate on the basis of nationality. Further, even if you could discriminate on the basis of nationality for a good reason, you haven't provided any reason. You have provided no evidence. You have engaged in what Posner calls nightmare speculation, and that's not enough. The preliminary injunction stands.
So nightmare speculation, not enough in this case. It is unfortunately enough in too many cases under too many judicial decisions, but it doesn't carry the day here. Moving on to the last two Judge Posner opinions involving two very similar issues.
Big day for Judge Posner today.
A very big day for Judge Posner.
Surely a career highlight.
And he turned out, Judge Posner is famous for turning around his opinions really quickly, and these were argued just a few weeks ago. And he got the opinions out quickly. So, Bob, tell us about Illinois Transportation Trade Association v. Chicago and Joe Sanfilippo Cabs v. City of Milwaukee.
So these are a pair of cases. They're actually unrelated cases outside of the fact that IJ represents parties in both and that they raise very similar claims and just happen to come to the Seventh Circuit at the same time in a way that allowed them to be heard in front of the same panel and allowed Judge Posner to turn out opinions in both of them on the same day, deciding essentially the same issues. But the first originates out of Milwaukee, Wisconsin, and Milwaukee, in response to a lawsuit IJ brought several years ago, a state court declared unconstitutional Milwaukee's cap on the number of taxicabs that were allowed to operate in the city. And as a result, the city did what the court ordered it to do and lifted the cap on taxicabs, authorizing new people to enter the market. And they were immediately met with a federal lawsuit by incumbent taxicab companies.
Now, this is not the first time that IJ has seen that kind of lawsuit when a city or a state deregulates its transportation market, right?
Now, it's actually very common. It's increasingly common across the country these days in light of new services like Uber and Lyft, but you regularly see lawsuits brought by incumbent businesses essentially making the argument that they have a right to a permanent monopoly in the transportation industry in whatever the relevant market is. That essentially it is an unconstitutional taking to allow new people into the market to compete with them. It's really a conceptually interesting claim because fundamentally what they're claiming a property right in is consumer dollars. They're claiming a property right in the business of consumers who would rather use a different service.
Yeah, they're claiming a property interest in their present market share, or in the case of the Milwaukee taxicab owners, you're actually claiming a property interest in an oligopoly that was established in virtue of this permitting cap. Judge Posner, I think, very persuasively and with great dispatch makes the point that, yes, you have a property interest in your ability to earn a living, your ability to the extent that customers are willing to deal with you, earn a living by providing goods and services that they desire and they want, but you don't have the rights and you don't have a property interest in preventing people from competing with you.
Yeah, so if the government had taken away the taxi cab drivers' licenses or medallions, that might have been a taking. But the mere fact that those medallions became less valuable when they were exposed to competition is not a taking.
Exactly. And if that were a taking, that would imperil the government's ability to do everything from opening new bus lines to legalizing new services like Uber and Lyft, which is what the parallel Chicago case is about. In Chicago, there wasn't an initiating lawsuit from IJ. That lawsuit actually was initiated before Chicago made any legal change at all in response to ride sharing. The original kind of gravamen of the complaint in that case was literally that Chicago police were allowing ride sharing services like Uber and Lyft to operate. And so the relief asked for in the original complaint was literally that the Chicago police go out and arrest ride-sharing drivers.
That's a bold move. How did that work out for them, Bob?
Poorly. It worked out poorly, Paul. So IJ intervened in both of these cases. They both were happening around the same time. We intervened in Milwaukee on behalf of one of our original plaintiffs who had benefited from opening up the permit system. And we intervened in Chicago on behalf of ride-sharing drivers who would prefer not to be arrested, which is an unusual claim. And both ended up in front of the Seventh Circuit. And following actually another IJ case from about 10 years ago out of the Eighth Circuit, where we litigated exactly this issue in defense of Minneapolis's decision to open up its taxi market, the Seventh Circuit comes to the right conclusion in a way that I think is going to have real implications for how cities respond to innovation and how cities respond to what we're seeing now, which is the wave of increasingly good transportation reforms all across the country from Sarasota to San Diego. Incumbent taxi companies routinely try to protest any sort of free market reform, anything that would open up the market, by threatening lawsuits. And I think both of these opinions by Judge Posner draw a pretty firm line in the sand that says states and municipalities can open up markets, they can remove existing monopolies without having to buy off the existing monopolist first.
Well, that news will come as a relief to anyone who's ever been stuck in the snow in Chicago trying to hail a cab. It seems like it's going to be a lot easier for people to get rides there. Well, that's going to do it for this edition of the Short Circuit Podcast. Thank you all so much for joining us, and be sure to tune in next week when we bring you even more exciting news about the most interesting cases from the federal courts of appeals.